My name is Janet Hicks, and I'm very pleased to introduce a panel on AI and visual arts, specifically AI in visual arts, challenges and opportunities for artist remuneration in the digital age. And it gives me great pleasure to announce our speakers, which I will announce now, and then they will speak on different topics. I'm well aware that we have an eclipse to see. So what will happen is we'll have first two of our panelists speak. Then after that, the break, and then finally, our final panelists will speak at the end after we return. So just keep that in mind when you're thinking about your questions. So I want to introduce the panelists. To my right is Christian Zimmermann, CEO of DACS. He's also a solicitor and has been with DACS for over 18 years, protecting artists' rights all along. We've worked together for all those 18 years. To my left is Scott Sholder, who gave me his bio. Is a partner at Cowan Debates, Abrahams and Shepherd, a New York law firm that, and he co-chairs the firm's litigation group. His practice focuses on litigation, counseling, and dispute resolution in connection with entertainment, media, intellectual property matters. Scott represents and advises clients ranging from individuals and small businesses to major corporations and A-list talent across various industries in copyright, trademark, right of publicity, unfair competition, and commercial and business disputes, as well as defamation defense. He's a frequent writer and speaker on topics landing in the intersection of new technology and IP, particularly the impact of generative AI on copyright law. So we're quite pleased to have him here as well. And then finally, on my far left is Paulina Holmgren, who's a freelance photographer, has been a freelance photographer for 25 years, and throughout her professional life has been engaged in the Swedish Professional Photographers Association. Since 2018, she's the chairman of the board. Pauline has also followed the entire implementation of DSM in Swedish law and has been engaged in cultural politics to improve the social and economic situation for artist professionals. Lately, a lot has roamed around generative AI. So I think we have a really great panel insofar as we have an artist, an attorney who's working on, who's going to give us an overview of various American court cases, and also one administrator within the system who could work on marketplace or licensing solutions that's coming from the UK. So we'll have a diverse group, even though there's only 3 of us. We'll start with Scott, and after Scott's presentation, I'll leave the floor open for some questions. Same with Christian, and then please be mindful, I will as well, on the time to make sure that we get out to see the eclipse. We aren't talking over it, so thank you.
Thank you, Janet. Hello, everyone. Thanks for having me. I will be talking about the current landscape of copyright infringement and other lawsuits dealing with generative AI here in the US. These cases have blown up over the last year or so. It started out with a couple, and then it was a dozen, and now it's close to 20, if not more. They generally are in two geographic locations. You've got the Northern District of California, Silicon Valley, where all the tech companies are headquartered, and the Southern District of New York, which is where we are right now, the federal courts here in Manhattan, which is where the publishing industry is focused. So we've got bi-coastal litigations going on. Some of these are class actions, some of them are individual lawsuits. And they're all at various stages of the litigation life cycle. So I'll kind of give a high level overview of as many as I can. This may not be all of them. There's been a couple that have come and gone that I didn't include, but this is generally where things stand now. So we could start with the first slide. So just a fair warning, these slides are very text heavy. I'm not a PowerPoint guru, but my wife would kill me because she used to do PowerPoints and, financial products, and it was all graphs and graphics and pretty things. And she would, yeah, this would not fly, but I'm not going to read from them, at least not all that much. But just, there's a lot of information, and all these cases are kind of at a different at different phases. So Getty Images versus Stability AI was the first, or one of the first cases, I think, if not the first, filed against generative AI tech companies. And this one obviously deals with visual images, Getty Images being a significant provider of creative content, photography, graphics, videos, etc. So Getty Images sued Stability AI for copyright infringement, as well as uh, trademark claims based on the use of their watermarks. You'll see I have there are only a couple of visuals in this presentation, and then this is one of them because two visual cases. So here you see the Getty Images watermarked photo on the left, and the product of Stability AI output on the right. Quite similar in terms of the players and the colors and whatever, but you also see kind of a garbled version of the Getty Images watermark there on the right in the right image. Not to mention the horrifically deformed body of the soccer player, which I think gave us all nightmares the first time we saw it. This is like is from a year ago, and these visual engines were still kind of messing up hands, hands with 7 fingers, and couldn't quite get the body proportions right. Now things have developed such that there's not really that many of those types of problems anymore, but it's just it's fun seeing historically how these things have developed. So if you could just go back to the previous slide for a minute. Thanks. So the output was not only kind of rendering arguably substantially similar photographs, but was also using the pairing of text and image, which is extremely valuable in terms of training these models. They need to understand what an image of a soccer player looks like. So you need a caption and text associated with that image. So the claims center around the use of the images and the paired text for training purposes, as well as showing the potentially infringing output. And then the trademark claims center on the watermark. So the use of the watermark, and then the output of the watermark, and it's potentially misleading people into thinking that this is a Getty Images sponsored image product, etc. So there's an amended complaint that was filed in March. There was a motion to dismiss that was denied without prejudice in January. So March of last year, an amended complaint was filed. And so this one is just kind of ongoing. So this is one of the big image cases. There is a UK parallel to this that I believe was filed first. That might have been like the actual first one in terms of big lawsuits against the AI providers. So that's Getty Images case. We can move on to the next one.
Way, just quickly to remove the image box
on
the right, just so we can see the full presentation.
You could probably just minimize that. Thanks. Yeah, that's great. Perfect. Okay, next one. Okay, so Anderson versus Stability AI. Oh, by the way, Getty Images one is in the District of Delaware. That's kind of the exception. There's a couple of cases in Delaware federal court. Anderson is in the Northern District of California. Just to give you an idea, these are not the images that are at issue, but this was just a prompt that I did. Red fire breathing dragon in the style of 1980s Dungeons and Dragons, which can tell you a little bit where I'm coming from. And like this is the kind of quality of images that you're getting from a Midjourney or a Stability AI. And in this case, you have some visual artists suing Stability AI, Midjourney, and DeviantArt, which is a platform for the display and to some degree the commerce in art, kind of dark fantasy type art, that had its own kind of built-in AI creation engine that I believe was built on the back of or built on top of Midjourney. So that's how they ended up getting brought into this case. There were some initial problems with this case right at the outset. In the United States, you need to have a registration filed with the Copyright Office in order to bring a lawsuit. So technically you own something as soon as it's copyrighted, which is when it's fixed in a tangible form, but that doesn't do you any good if somebody infringes your rights. You need to register with the Copyright Office, where I think we're the only country in the world that requires that. So two of the three artists, I believe, didn't have registrations for their works. That was obviously a problem. And then there was also the lack of identification of specific works that were infringed. So there was no indication of what works the plaintiffs were talking about specifically. So a motion to dismiss was granted, except with respect to the direct infringement claim, and that was the plaintiffs were allowed to amend that. And there has been a motion to dismiss the amended complaint that was filed just well, not last month at this point, in February, and there will be a hearing on that this month. So we'll see where that goes with the new version of this complaint that did have its issues, but you know, in U.S. courts, you get a second bite of the apple. So we'll see where this goes. See where this goes next. So go to the next slide. Thanks. So everything from now on, for the most part, is text-based. So we're talking about rather than diffusion models and image generators, we're talking about large language models and mostly ChatGPT. This is one of the, sorry, I can't, the toolbar is blocking the case caption. I can't see which case this is. Oh, Tremblay, okay. Oh, thank you. All right, Tremblay versus OpenAI, also pending in the Northern District of California. This was a class action of authors suing OpenAI for ChatGPT's use of works as training data. There were allegations in this case about the creation of derivative works. So the output being derivative of the works that were ingested. I believe there were some allegations that the LLM itself was a derivative work of the input. Some things that the judges in these cases weren't really buying into. This case also included a Digital Millennium Copyright Act claim. For those, if you don't know what that is, it deals with the alteration or removal of copyright management information, which is things like author credit, title, copyright notice. If you tamper with that, if you modify it, if you delete it, that leads to a separate cause of action outside of the infringement context. And there were state law claims as well, unfair competition, which is kind of like trademark type claims, negligence, unjust enrichment, which is a pseudo contract claim saying you basically enriched yourself at the expense of others. And there were motions to dismiss filed in this case as well. Those motions were granted in part. So there's a list at the front here of which claims were dismissed. Quite a lot of them were dismissed. An amended complaint was filed last month. And this case falls within a family of cases that was consolidated. So if you've got Tremblay, you've got Chabin, and you've got Silverman. So Sarah Silverman, comedian and author, brought another text-based class action lawsuit. Michael Chabin, another well-known author, and these were all consolidated with Tremblay in the Northern District. I may touch on this again a little bit later, but there was a motion to intervene by some of these parties. The California plaintiffs sought to intervene in the New York actions, which we'll talk about, to try to either stay them, like press pause while the California actions played out, or to dismiss them based on various procedural wrangling. Neither the judges in California nor in New York were having it. They denied those motions, so that's no longer an issue, and the bicoastal litigation will continue. So we can move on to the next one. Okay, I can just go from here. So some of these, so Chabin, the next one is, I don't have to go into too much detail about this. This is another of the companion cases with Kadri. So you've got Tremblay, Silverman, and Chabin that are all relatively similar. So the Sarah Silverman one is the one that got the headlines because it's Sarah Silverman. She and a couple of other book authors brought very similar claims alleging copyright infringement. Again, DMCA removal or alteration of things like credits and author names. The procedural posture of this is the same as the one we just talked about. Their motions to dismiss were granted in part. Amended complaints were filed on March 13th, and the motion to intervene was denied. Okay, move on to the next one. Chabin, again, falls within the same family of cases, so we can skip that slide. Cadre, again, these are all of a piece. So, but this one is against Meta platforms. So it's the reason it's different because the defendant is different. But it's again Sarah Silverman and some fellow authors filing class action same day the other one was filed, based on essentially the same allegations of copyright infringement, DMCA, unfair competition, negligence, et cetera. And this time against Meta for their Llama product as opposed to OpenAI's ChatGPT. Same procedural posture. Okay, Authors Guild versus OpenAI. Disclaimer, I am one of the co-lead counsels on this case. So don't expect me to be very even-handed about it, or any of these cases for that matter. And if you ask me about fair use, I'm not going to talk about it. I have to be careful what I say. It just is what it is. But this is our case. Filed in September of last year against OpenAI. So the Authors Guild and 17 prominent fiction authors came together and brought this class action against OpenAI, and later on added Microsoft as a defendant. And our allegations include direct, vicarious, and contributory copyright infringement. So you've got direct infringement against the main OpenAI entity, and then these secondary claims of infringement against other entities and against Microsoft. I won't get in. I don't have time to get into the technicalities, differences between direct and indirect infringement, but the claims are based on input, ingestion for purposes of quote unquote training, and copying materials without permission to teach these models to essentially spit out market competitors and infringing derivative works. And we don't have a claim directly on the output, which is what makes this case a bit different from some of the cases in California. We're focused on the input. Obviously, the output is important for various reasons, but the input is really the focus of the claim. So our interim lead counsel motion was granted. We are still relatively early. Various motions were filed. We've been consolidated with another couple of cases for pretrial purposes because they were filed slightly after us, but the allegations are similar. And so we're in front of the same judge for purposes of administering the case, at least up until class certification comes about. And then this, as I mentioned before, the California plaintiffs in some of these other cases tried to intervene to dismiss this and the related cases in New York, and that didn't go very far. So we can move on to the next one. Alter is our companion case in the Southern District. This is one of the ones that was consolidated for pretrial purposes. So our class is of fiction authors, and the Alter class is of nonfiction authors. So ultimately, the two cases were put together in front of the same judge, but the allegations are essentially the same. And then after we filed our amended complaint adding Microsoft, we then filed a consolidated complaint together with the Alter parties. So now we've got one kind of omnibus complaint dealing with both cases. Allegations are basically the same: direct copyright infringement, vicarious and contributory copyright infringement based on training for training the LLM underlying OpenAI's ChatGPT. Okay, we'll go to the next one. Basbanes is another kind of related case. It was consolidated for pretrial purposes as well. This is another couple of nonfiction authors. I believe they're journalists who sued for, again, similar allegations of copying of books and articles for training ChatGPT without permission. Go to the next. New York Times versus OpenAI is actually not related to our case. It's not a class action. It's an individual action by the New York Times against OpenAI. But it's also in the Southern District, so we're all together in New York. But this one is on a different track. So essentially, this is an individual action arguing, again, similarly, that the companies behind ChatGPT used copyrighted news articles, investigative pieces, opinion pieces, et cetera, to train both Microsoft Copilot and OpenAI's ChatGPT. So this case has copyright infringement allegations, obviously, but also DMCA, as I mentioned before, unfair competition and trademark dilution because of certain uses of the New York Times name that came out in the output. And in the complaint, there was demonstration of regurgitation of exact kind of replicas of some of these articles and opinion pieces, which got a lot of attention in the news, and the defendants have moved to dismiss. They have some, I know they had some issues with what they thought was engineering of the system to try to get it to spit these things out. But the fact of the matter is that verbatim copies came out the other end. And so that will have to be determined during discovery, how and why that happens. But right now, there's a motion to dismiss pending as of the end of February. The grounds include statute of limitations, which is one we haven't, at least I haven't seen in the motions to dismiss before. So that should be an interesting theory to see where that goes, given that these models haven't been around for that long. Failure to state a claim on certain claims, the Digital Millennium Copyright Act claim and the contributory infringement claim. And there is an argument here that some of the trademark type claims are preempted by copyright, which just means that in the federal system, if you have state claims or other federal claims that essentially seek to vindicate the same rights that the Copyright Act would, the Copyright Act will supersede those and they'll essentially be duplicative. So that's one of the arguments that they're chasing here. So we'll just waiting to see what happens here. If the motions were filed in February, responses wouldn't be due until sometime now, and then reply briefs come after that, and then who knows how long it takes to decide the motion thereafter. So move on to the next one. Okay. This is a new one, the NVIDIA court case, another class action lawsuit brought by authors against NVIDIA, this time for this tech company's training of its model, Nemo Megatron, which is like the coolest name for a tech product I've ever heard. So props to them for that. But so it's a 1-count complaint, direct copyright infringement for using TextWorks to train the model. That's it. And the allegations include training on what's called the pile, so the massive data set, which includes books 3, which you might have heard of, a source of copyrighted text materials potentially sourced from pirated websites. And this very early, so complaint was just filed recently. Okay, go to the next one. Raw Story is another very recent case brought by news organizations. So now you're seeing news organizations like following the New York Times case, journalists and news organizations coming out with very similar claims to the fiction and nonfiction authors. What's interesting about this one is that there's an allegation of copying of investigative journalism pieces and kind of regurgitation of verbatim text without attribution, but there's no direct infringement claim in this case. This is solely a DMCA case. So there's 1 count for violation of the section 1202B1 of the Copyright Act, which deals with removal of copyright management information. So there's no direct or secondary infringement claims. It's just a DMCA case, and the complaint was just recently filed, still in the early stages. We'll see where it goes. Intercept is very similar. This is another news organization that sued for DMCA violations for copying various journalism pieces. But this one has 3 counts. So it's got, there's multiple defendants. There's OpenAI and Microsoft. So you've got a 1202B1 claim against OpenAI and Microsoft. So count 1, count 2. This is the removal of copyright management information. And then 1202B3, which is a little bit different. It's sharing materials with somebody else that lack copyright management information. So you essentially strip the CMI off and then essentially given it to somebody else. So the allegation here is that the materials, the kind of purloined materials, were shared with Microsoft to train its Copilot program. Again, no direct or secondary infringement claim, so it's pretty interesting. Okay, go to the next one. JL, just touch on really quickly. It's about this is against Alphabet Inc., so the Google parent company, and this is a class action brought by individuals arguing that Google engaged in unauthorized scraping of like everything, right? Data from everywhere on the internet, including within the Gmail app, within Google search itself, to train its own AI products. This is not just a copyright claim, copyright case. There is a copyright claim by an author who's one of the named plaintiffs, but there are various privacy violations, property like torts, all kinds of different state law torts. If you have, several hours to read 100 some odd pages, it's pretty, it's dense. It's yeah, it comes out strong. So it's an interesting read if you want to hear the plaintiff's side of what Google is allegedly doing with everyone's data. So this one is kind of pending, right? There's a motion to dismiss that was filed, and that it's not even close to being decided. So we'll go to the next one. All right, this is the last one, I believe. So Ross Intelligence. The reason I put this in here is a little bit older, but this is the only case that has a decision on the books, and the decision doesn't do much to help us. This is Thomson Reuters versus Ross Enterprises. So the Thomson Reuters parent company of Westlaw legal research platform suing for use of its case law, including not just the case law, which is cases themselves are government works, so can't really own those, but there's proprietary commentary, analyses, organizational systems, head notes. If you've ever used Westlaw, there's a organizational system where you can link to certain content. So this allegedly was used by Ross Intelligence to train its AI product to create essentially a market competitor with Westlaw. So there's a motion for summary judgment, which means you've gotten to the end of the discovery process based on all the evidence. Can somebody win before trial? No, not here. Not on the issues that we all want to know about. Fair use, copyrightability of the Westlaw head notes, all the big copyright issues the judge decided have to go to trial. So we will know a little bit more about that in August, the end of August, when the trial on the copyright issues is set, assuming it doesn't settle beforehand. So this is the only decision we have on AI training, and it gives some maybe a little bit of, might read the tea leaves a little bit, but not really. It's going to be up to the jury to decide what is and isn't fair use. So we'll see where that goes. I think that's it. Oh, I had Concord Music Group. This is the one music case that's out there. It's music publishers suing a music generating AI platform for copying song lyrics. So I think I am out of time, so I won't spend too much time on this. But again, copyright infringement, vicarious infringement, removal and alteration of copyright management. You see the pattern, right? And it cuts across the various artistic disciplines. So there's no order yet on a motion to dismiss here or a motion for preliminary injunction. So this case is just kind of sitting and waiting for next steps.
That's it.
I think that's it. I hope that's it. It's a lot of cases.
Great. And, this is the visual arts panel that was very text heavy. We did want to have Scott, because he is an expert on this, to talk about all the cases here, both text and visual material. Well, why do you think there are so few visual arts cases? What are the hurdles for visual art? Is it registration? Is it other things?
Well, I mean, it might be registration to the extent you're talking about photography, because photographers tend to have, huge portfolios of material, whereas a painter, a traditional painter might have, a much smaller repertoire, I guess. But there are mechanisms for being able to register multiple photographs at a time, but photographers who don't necessarily have legal counsel don't know that. And so they think, oh, it's like $50 a pop to register every photograph. So that's certainly possible. It could be that people just don't know you have to register your works. It also could be a matter of proving up what's in the data set, right? These data sets are notoriously opaque. Nobody really knows what's in them. It's a lot of guesswork and kind of working backwards to try to figure out where everything came from. I think one of the problems in the Anderson case was the plaintiffs didn't say what works were being infringed. I don't know whether that's because they didn't know they were supposed to do that, or whether they were unable to generate something that looked like their works. You can say, make me an image in the style of Picasso, but Picasso's style itself is not copyrightable. So if it doesn't look like a specific Picasso work, you may have a hard time asserting a copyright claim. So text is easier, I think, to potentially generate an infringing derivative. That doesn't mean you can't do it. And it doesn't mean it hasn't been done. And obviously, if the Anderson and Getty Images cases continue, Getty Images, goes on. But if the Anderson case goes on, obviously they must have shown something. So there are ways to do it. It's just, I would say probably a little bit harder on the visual art side to generate what you need to generate in order to form the basis of your claim. Yeah, I think that's that. Again, I'm not a computer scientist, so that's just my assumption based on what I've been reading. Yeah. Okay, well, that's good. I'm in good company then.
Yeah. I wanted to have some questions after this, but I'm mindful of time and I want to make sure Christian gets his full time in. So maybe we'll have questions after the eclipse and after Christian gets his 15 minutes now. So
Thanks,
Christian
Janet.
From DACS.
I try to be quick so that you can all see me or can see the eclipse. Just going into my presentation about AI and visual arts in the UK. There's currently no regulation in the UK. The EU AI Act does not apply in the UK because of Brexit. And we have a government that is very keen on creating an environment that is conducive for AI companies to do business. So we had a proposal from our government to create exceptions for AI companies, but that met with quite a lot of resistance from the industry. If you want to go to the first slide, please. And that resulted in the government asking, can you move the slide, please? Yes, thank you. And that resulted in the government wanting to create a voluntary code of practice between industry and rights representatives. But after nearly a year of negotiations that failed, and the government now conceded that that isn't the way forward from earlier this year. Only last month, we had a bill introduced by one of the lords in the House of Lords. Lord Holmes wanted to or proposed an AI regulation bill. Elements of this would be to create an AI authority and the usual elements of transparency and IP protection are present in the bill. But the problem with such a proposal is that this is only a starting point for a debate around regulation. So there will be a lot of time until there will be a decision. But what it could potentially be for the industry is a basis for an argument with government for regulation. If you want to go to the next slide, please. You've just seen these images because this, unfortunately, as was just outlined, is literally still the leading case in the UK, which is Getty Images versus Stability AI. In the UK, the Getty sued for the same things that they sued here in the US, but also for the database right. And they also sued for secondary infringement for Getty making a tool available to the public with which copyright could be infringed. I will not repeat everything that Scott has said, but it's exactly the same points about the trademarks. If you want to go to the next slide, please. We included another couple of quite outlandish images for you there as well. It may not be as, not this one. Please go back one. Yes, thank you. That kind of emphasized the fact that at the time it wasn't great what the Stability AI came up with. But on this one as well, we had to wait a little bit longer in the UK for Stability AI to file their defense, which they have now done. And their defense is that basically the Stability AI database or the large language model was trained in the US, and therefore the UK courts do not have jurisdiction. And also in the US, fair use applies. So we basically have a circle argument here where we're basically relying on what will be found in the US. And if there was jurisdiction for the UK courts, Stability AI has now claimed that a defense applies in the form of pastiche. We have a fair dealing defense for caricature, parody, and pastiche. And Stability AI said that the pastiche element would be also in line with how the technology works, which does not directly copy. But the synthetic image generated by its model are diffused from random noise. So that's basically what was claimed as a defense in the UK. If you want to go to the next slide, please. The issue that we also have, and I've again, like Scott, prompted here an engine called Imagine AI Art with painting David Hockney pool with men. And you see the generated image on the left and the two original David Hockneys that you may know on the right. And again, you can see that there isn't necessarily a direct copying taking place. The problem we have in the UK is if we wanted to show infringement, we would need to show substantial taking. You can definitely see elements of the original works in the new work. If you want to go to the next slide, this is the same prompt put into Midjourney. Again, probably less likely like in the previous slide, but you can see, for example, the tiles on the left side are in the same style as the water was in the original and in the Imagine AI Art reproduction. But again, it's probably more the style that has been copied. What I find very telling, though, if you want to skip back to the last slide again, if you look at the original and the composition on the top with the green in the background, I mean, that's not in the prompt at all. So it's not saying and show me a landscape around it, but in the left one and on the next slide again, both images show exactly that kind of green in the background and the composition of the work. So I think what we will need to see is if there can be a development of the concept of what substantial taking is, because in my view, there is definitely more than just the style. It's the composition and it's an essence that is kind of coming through in these copies. Next slide, please. At DACS, we have also carried out a survey and we received 1,000 responses from artists and those representing them. And apart from them answering our questionnaire, we also had more than 350 comments about what artists feel will happen to their works and copyright in an age of AI. And many expressed very eloquently their fear that they will be replaced in the medium to long term, which we've also heard about this morning already. And we at DACS have already heard from many illustrators and photographers that certain streams of works have dried up and companies are cutting positions to a few who oversee the output of AI rather than actually creating. And although painting and, for example, sculpture will probably be less affected in the short to medium term, there's a real issue about the whole ecosystem that we're already seeing. Because, for example, an art students entering the industry may have to make do with some smaller pieces of works that are now being carried out by AI and therefore are discouraged from actually taking up the profession. So what we will be seeing, and I think that's what we need to all work together in order to avoid it, is that ultimately this will lead to a significant reduction in talent entering the industry and in particular in diversity, so that only those can really start working as an artist who can afford it from scratch. However, next slide, please. We have already seen also a few industry-led solutions, and we've heard about some of them this morning already. If you want to go to the next slide, please. For example, here's a project that artist Damien Hirst engaged with. He partnered with an AI company that was purely trained on his spin paintings, and then he allowed collectors to put prompts in to create digital versions of their own spin paintings. And I think that shows that there's a potential market, in particular when you have a certain body of work that you can use. And like Damien, there's a lot of artists who see AI simply as another tool that they can use it as part of their creative process, like a camera or scanner or computer. However, we still have that main issue also in the UK that there's no clarity about copyright in the resulting or the AI-generated image. So unlike the Copyright Office here in the US that has decided that it's not granting copyright protection to those parts of the work that are AI generated. In the UK, we don't have a registration system, so there is no such entity to make such a decision. So we have no certainty around the issue. And that in itself can cause quite a lot of uncertainty and inhibitions for people to use it, because if an artist uses AI in creation of their own works, they obviously want copyright protection. But if there may be none, that could be an issue going forward. Similarly to them using AI systems that are potentially infringing, then they may themselves find themselves to be infringing. So that whole uncertainty part in that area is really kind of inhibiting artists from adopting those solutions more fully. If you want to go to the next slide, please. This is again an example, Getty Images. Getty Images have created their own AI, but they have also partnered with another company called Bria. This is an AI, or also their own Getty Images AI are models where they have licensed the content to be for the training purposes of the system. And that specific AI can actually tell you what works it relies on when it creates a new image. So that can help, for example, if you have a licensing solution, to distribute royalties very accurately about how important an image was for the creation in a new output. There's other examples like this, like Adobe's Firefly, or there's a company called Visual, and I think this morning we have seen some other ones. In the case of Getty, what is interesting because of this uncertainty, again, if there is copyright or not. So Getty does not lay any claims to copyright in any of the outputs, nor does it allow them to be ingested back into the Getty database. So that they allow for people to use it, but they don't want the images back in the database. If you go to the next slide, please. So as I mentioned, there are already some licensed solution available, but obviously this does not address the wholesale copying that we see that large language models or diffusion models are carrying out, and it doesn't remunerate creators for the use of the works. We envisage that this may be possible through individually negotiated blanket licenses or ECL schemes, which we have in Europe and in the UK, hopefully soon in operation as well. Or meaningful laws could be introduced that allow, for example, for levy systems, like in 48 countries currently throughout the world, that kind of are used for private copying exceptions or reprography. And then there is also a lot of other solutions, and I think any legislative solutions would need to be accompanied by opt-outs. So we work with a company called Spawning AI that allows for opting out content for training purposes. And for example, a company like Stability AI adheres to these opt-outs that Spawning creates for their databases. When we ask our membership, that we had nearly 84% of respondents saying that they would be happy for something like the described licensing solutions. If you want to go to the next slide, because again, as we've seen in the stats this morning, 95% of our respondents simply want to be asked before their work is being used, they want to be credited, and they want to be compensated. And on the basis of the responses that we had from our survey, if you want to go to the next slide, please, we've also created some recommendations similar to the ones that we've seen this morning. So I think there is definitely reassurance in all of us coming up with more or less the same solutions and principles. Basically, the consent, control, and compensation are important, that we want transparency, and that there should be a regulator that basically enforces the two sides accurately. We also included, or had as a result, international competitiveness, because, as I said before, the UK government really wants to create a landscape for AI companies to do business well in the UK. And in their mind, so far, that looks like no regulation or very kind of accommodating regulation for companies. But obviously, the internet is a worldwide tool. So I think international competitiveness is key, so that we don't have a race to the bottom, and that we don't kind of find countries that where there's minimal protection having the most attractiveness to AI companies. And then obviously to incentivize human creativity and to ensure that there is a pipeline of new talent coming up, and not only the people who currently have a job losing their jobs, but also that the future generation will have an incentive in engaging in the creative arts and enter into the industry. And that's it. Thank you.
So it's 3:05. Do we make it outside? Is there a place that, Mary, you saw that we should go to?
But I think
From the street, yeah, I think so.
somewhere on the street, you'll be able to see.
And we'll take a short break, I guess, for everyone online who doesn't care. And your photography.
Yes, thank you. Thank you all. And thanks, Scott and Christian, for your presentations. It's very interesting with all this lawsuit, because we don't have that in Sweden and Europe as you has. Yes, I'm a photographer and I've been a freelancer since 25 years ago. So for me, when I started in the 90s, it was easy with copyright because I had my own negative. I owned the original. And I sent copies to the magazines and they published my work. And when they had published, they sent back the copies to me. So I have full control over my own work. But with the digital, it's totally different. So in the beginning of the 2000, a lot of things happened because all my images are copied all over and the internet. And now AI is here and things are even more complicated. Yeah, where should we go? Where should we start with challenges, or I don't know.
Well, do you use generative AI as a tool? There's been a lot of discussion about using AI as a tool, as a beginning place for artists. Is that something that you use?
Yeah, I think it's kind of complicated because AI as a tool can be different things. It can be if I have my own photograph, I can only use it for color correction or adjustments, but I can still also use to generate new stuff outside the actual photograph. So I think before AI, photographers used other tools to get the image bigger. If you have like a portrait format and then do a landscape, you could use clones or other things to do that, but now it's like easy. So I think photographers use it as a tool, but still the original is from a lens-based photography, I would say.
Yeah, and then on the flip side, there's a discussion we learned in earlier presentations, especially with authors, how several authors are losing compensation and finding they're getting fewer jobs because of the advent of AI. Have you noticed that particularly in your line of work or other photographer colleagues? Do you have any examples of this?
Absolutely. I think for both photographers, illustrators, like everyone working with visual art is definitely, because we also have a couple of years behind us with the pandemic that we lost a lot of jobs. So now it's so easy with this tool. I mean, it's a tool for me in my profession, but it's also a tool for like everyone to generate images, and they can do almost photorealistic images. And I think that's also a big problem with with fake news, and it's a threat against photojournalism with that kind of. You can make photorealistic images that's with persons that don't exist, environments that's not for real.
Yeah, or royal family photos, for example, can also be altered to. And are there mechanisms in place for people to easily tell if it's a photograph that's been altered or created by a machine?
I think as a photographer, I can see because you can see it in daily life, like all the time in social media, images, and people can have that hashtag, wow, fantastic photography and stuff like that. And I can say, this is for real. It's definitely AI generated. But I think maybe that's because it's my profession. I don't think all people can see the difference. And when AI is getting better and better, so we might not see the difference. But that thing, I think it's really important then to think about the transparency, both for the AI developers. They have to be transparent about what's trained on, but as an artist, we have to be transparent of how we use the tool, and have rules and how we use it, both at least in photojournalism. It's really, really important.
Some ethical guidelines.
Ethical guidelines
for
absolutely,
not only
absolutely.
creators, but also for the end users too.
Yeah.
I mean, I would think that most people would rather work with a company that is certified to
Yes.
only use ethically sourced images
Yeah.
than not.
I mean, the source will be even more important in the future, I think. So that's why if you work as a journalist or a photojournalist, it's really, really important that you follow ethic rules.
Yeah. And we saw in Christian's presentation that most of the artists at DACS, for example, are in favor of, if they're going to be ingested, they want to be credited and have compensation. Do you think that's the same in Sweden as well?
Yeah, absolutely. We're talking a lot about licensing in Sweden because we already have that kind of system in Scandinavia that's working for other exceptions in the copyright law. But I think one problem is all about opt-out, because so many is talking about opt-out, and I don't think that will work. How should that work? So we have to find another way to get money back to the actual artists and authors to get back in the system so human can continue.
Yes.
Be
Yeah.
creative, I think. Yeah.
Yes. You had also mentioned before, we talked about some other EU cases, like this German case that's come up.
Yeah.
If you want to talk
Yeah,
about that.
that's thought about when we talked about there's not that many cases, but I think this is the first case in Europe. It's a German photographer. His name is Robert Kneschke, and he sued the German organization Lion for infringement, copyright infringement, and his images has been used in a giant database for training. And it's I think the German court will look at this in late April. So soon we maybe will know more. And I think this is a case that is important for whole Europe, because they're looking at the exception, TDM, text and data mining. So I think this will affect both Sweden and the whole Europe.
And yes, and they'll hear it when in fall, you said?
April.
April. Oh,
Yeah, but
this month.
we don't know what
okay.
happened after that.
Oh,
but
okay.
maybe they have to consult the European Union court in this case.
Okay. Okay, great. So I want to sort of open up the floor for questions as well too, not only for Paulina, but for any of the panelists as well. So we could all have a sort of lively discussion about what's going on in visual material. If anyone has any questions, or I could continue to ask some questions. Anyone from watching from the internet as well? Christian, how do you feel, we talked about, legal cases. Do you think that there's a good solution for a market-based, solution for AI for compensation for licensing?
Currently there's not, because we're still at this impasse where rights holders and AI companies are trying to find a solution through the courts, and that's potentially gonna continue, even if we have a solution. I think in the end of April in Germany, there's appeals that can go on, and it's the same in the Getty case. So I think you've seen this in the UK with this attempt of having a code of practice where you had rights holders and AI companies sitting around the same table. Then nobody said anything because nobody wanted to prejudice what was currently being going on in the courts. So I really think we need the regulators to come in and then allow us to find market solutions on the back of that, so that we kind of get out of this situation whereby we are being referred to the courts. And I think it's also not right, in my opinion, to leave that to the rights holders to enforce their rights in this way, because as we've heard this morning, that these companies, they have very, very deep pockets. And in particular in the visual field, you talk a lot about individual rights holders, freelancers who just simply don't have the means. So for example, we don't have the same type of class action in the UK that you have here in the US. So you would find a lot of individuals having to sue big corporations that don't really, it's not feasible considering the time and the cost involved, and the uncertainty really of what the outcome would be. Particularly in the UK, we have a very reduced damages system. So all you could, well, there's exceptions, but on the whole, you would get a license fee and risk sitting on the costs for the legal case. So I don't think there's many artists who could really afford doing that, and I think that's an issue.
I just realized that we've gone over time. Sorry about that. So, but maybe we have time for one more because we're 5 minutes over. What should I do? Yes?
I was interested in Scott's perspective on what Christian just said. Do you think if the copyright infringement cases vindicated the right in the context of ingestion, that gives individual authors a path forward? Or do you feel we're in the same situation that Christian described, where it costs too much and we get too little, and the copyright law just doesn't give us an answer? It's not a good paradigm.
Well, so I think to some degree, if the cases go in favor of the creators, then yeah, I think it does pave the way for some sort of market-based licensing. I frankly, I think that can be done even notwithstanding the litigation. The difference between, I think, the European system, I don't know much about European copyright law, but the US copyright law has built-in statutory damages, which can be quite high per work. The range is from 30,000. Well, it's a minimum of $750, go up to $30,000 per work infringed. If it's the infringement is willful, it can jump up to 150,000 at the highest. So there's significant kind of financial consequences, more so than maybe in European countries where people have to kind of, they're footing the bill, and they're only going to get a license fee out of it. So I think there's more leverage in terms of US litigation, and there's fee shifting if a prevailing party can potentially get their legal fees covered. So I think a win certainly would put more pressure on the players who are using the content to say, well, I don't want that to happen to me. I mean, large damages awards, having to pay everybody's attorney's fees, that kind of thing is a significant deterrent to future infringement. But I mean, I hope that resolutions can be reached, much like happened in the music industry and after the kind of the Napster era. Now it's, say what you will about the compensation structure, but it's there and people are getting paid, as opposed to just music being given away for free as the mainstream option. So I'm cautiously optimistic.
And with that, I think we'll wrap up this session. Thank you to my panelists for great presentations and great questions as well. And I think we're now for the country reports.